people are resolving millions and millions of disputes by mediation, and not just in the United States. In fact, it's a global phenomenon. There are more rapid growth rates in Europe and Asia now than in the U.S. So this is a global phenomenon. In terms of where mediation is growing, certainly in South America, Argentina would be a good example. Throughout the European Union, they're taking mediation extremely seriously. There are a number of edicts by the European Union with requirements for member countries, particularly as to transboundary disputes and commercial disputes. Asia is very serious. I mentioned Singapore already, but everywhere. Japan, Indonesia, Thailand, Jamaica. It's really everywhere. And the best information I would offer would be in terms of people that actually make a living as mediators. I would figure in the domestic U.S. between 10 and 20,000. In terms of the total number of mediators, including community mediation programs and volunteer mediation programs, I'll bet the number is between 80 and 100,000, so 4 or 5-fold the number that earn a professional living doing it. And then internationally, my numbers would be much less reliable. It's ultimately based on a myth. The myth is that we could ever give people justice or access to justice. The reality is there's so many disputes now. You know, even without the mediation stuff, 97% settle. Okay, so all along, people really haven't had access to, the corporations and the people with a lot of money in their pocket, I suppose they do, but for most people, they really, as a practical matter, have never had practical access to the courts, and less so all the time. Less so. So in many ways, mediation is becoming the day in court, that we really never had. And it's a good day in court. It's a day where you get to say what's true for you. And it's a day where you have responsibility reflected back in your lap and say, well, what do you want to do about that? And can you guys come to agreement? The question, why the growth of mediation? And mediation is different things to different people. To a disputant who's well educated, it may be an opportunity to sit down and figure things out, at least a preferred opportunity to waging war in the courts. For an administrative agency or for a court, it may be a docket management device. There will very likely be a public policy supporting settlement and supporting people doing it on their own to the extent they can be assisted to do that. But of course, courts are going to be of limited resources also. And their primary mission is in fact to do justice. And so we run into what is, I think, perhaps one of the great tensions of our time relative to mediation, which is that to the extent that the courts and agencies have become gatekeepers for the publicly sanctioned mediation programs, not only publicly sanctioned, but usually publicly subsidized mediation programs, what we force people to do is to polarize and legalize and to submit a court or agency filing to gain access to mediation services, because the courts and the agencies can't do anything about anything unless they have jurisdiction, and the only way they get jurisdiction is that somebody files a legal claim for which they can provide relief. And so we have somewhat of an antiquated system, which is that we want people to mediate. We're in fact often going to require that they mediate, but the only way they can mediate is if they file a due process complaint, legalizing and polarizing the situation. And it just seems a little bit goofy that we would force them to do that when the first thing we're going to do once they do it is try to get them together and resolve it. And you wonder whether there might be some kind of mediation jurisdiction or some other way of parties accessing quality mediation services without having to legalize and polarize to do that. Future of mediation is multifaceted. It's already greatly influenced our culture as a whole, and so we have a wide variety of collaborative, facilitative processes that just didn't exist in the past, whether it's facilitated public policy or collaborative law or collaborative practice or the like. These are things that would not have existed but for mediation breaking through as a collaborative problem-solving process. So we've actually spawned a greater variety of collaborative processes, whether they're called mediation or not. And many things are called mediation that are very different. Everything from a 3 or 5 meeting, very capable problem-solving effort, down to an hour in a courthouse basement. The logic and common sense of mediation will continue to carry it into every nook and cranny of our society. And what we can hope for is that that's a thoughtful development where we're continuing to try to help people have capable mediation discussions, not just any mediation discussions. So the question is, how do you become a mediator in a realistic way? And the answer, I think, depends on the particular area of practice that you're thinking about. Just for example, let's pretend you want to become a public policy mediator or work with the large groups. Well, the way I think you do that is you carry somebody's bags for a while and you work with them as almost an apprentice, and over time you start getting introduced to their networks and you help them out as kind of a sub-mediator, and you just kind of work your way in. The way you would become a mediator for divorce is quite different. Number one, if you're not a divorce attorney at this time, you've got kind of a hard road to hoe, because you're going to be competing with those divorce attorneys who can also mediate and deliver a written work product that non-attorneys may not be able to. So if you're not a divorce attorney, think twice would actually be my practical suggestion. If you are a divorce attorney, then you're going to want to not only take one of those 40-hour required courses, but a whole lot of education to start thinking about the situation in a little bit of a different problem-solving way. For people who are looking to mediate business disputes or commercial disputes, I have found that in many areas, employment, workplace would be also true, that there are often two markets. That there's a pre-litigation market. For example, a hospital or college or university or corporation that has a workplace conflict in a department, or perhaps between a supervisor and a supervisee, and nothing's been filed yet. There hasn't been a grievance filed, no administrative actions, no court actions. It may well be that the gist of trying to deal with that situation is to keep it from becoming legal, and that the folks involved in that situation might actually want a mediator who's not an attorney, simply because they want to keep it at the relational behavioral level and try to get better things happening. So whether it's a good decision or not, when there's an actual legal action that's been filed, people are going to tend toward attorney mediators. The bottom line for people thinking about going into mediation is you're going to need to niche. You can't be a mediator for all occasions. You'll end up being a mediator for no occasions. What you want to do is think about 2 or 3 particular practice areas. It might be parent-adolescent, or it might be land use, or it might be business, or it might be workplace, or family, or adoption, or whatever it is. But think about 2 or 3 discrete areas that you can really develop yourself as a specialist, and also areas that have a bit of a network that you can interface with. It might be elder care would be a good example of a network that's very identifiable. You can go to the facilities, you can make your presentations, and folks in this environment have a variety of disputes that you may be able to help them with.